Chair at this time lays out House Bill 1899, recognize Representative Sanford to lay the bill out. I understand there is a committee substitute. The chair at this time offers up the committee substitute to House Bill 1899 and recognizes Representative Sanford to explain it.
Thank you, Mr. Chairman. Members, it's a privilege to be back in front of this committee where I served last session, and this is the first session, regrettably, where I'm not serving on a committee where Mr. Dutton is chairman. I do miss you and your team.
We miss you as well.
But, pardon me?
We miss you as well.
Oh, thank you.
And we just said we trained you well.
Oh, good. She did do a good job at that. Thanks for the opportunity to lay this committee substitute out before you today. The committee substitute of 1899 added, this is where the substitute comes in, HB 2643 to the bill at the request of stakeholders. And that bill, and now part of this committee substitute, relates to the rendition by the court in a suit affecting the parent-child relationship of a temporary order over the objection of the child's parent. In 2000, the U.S. Supreme Court in the case Troxell versus Granville defined a fit parent as one who adequately cares for his or her children. However, this definition has not yet been included into Texas law. The committee substitute 1899 would rectify this by placing the definition of a fit parent into code. Additionally, this legislation will prohibit judges from issuing temporary orders over the objections of a fit parent. The court would only be allowed to issue a temporary order over the objections of the parent if the parent is not adequately caring for their child. The committee substitute of 1899 is legislation which was brought to me by the Texas Homeschool Coalition. We have a witness here, of course, that is available to answer additional questions.
Any questions of Representative Sanford, members? Representative Sanford, thank you. We'll give you the right to close.
Yes, sir, thank you.
Chair at this time calls Mr. Tim Lambert, testifying for House Bill 1899 on behalf of the Texas Homeschool Coalition.
Thank you, Mr. Chairman. Tim Lambert with the Texas Homeschool Coalition. The first time that we got involved in one of these cases was in Ector County in 2000, where in-laws sued a homeschool family because they were vehemently opposed to their homeschooling. And that case went to court for a long time, and the judge in that case spent a long time discussing whether or not it was in the best interest of those children to be homeschooled. And of course they were fit parents. There was not any allegations of abuse or neglect. So this is the reason we support this language. I think it's common sense. It's a Troxell decision, and we're simply codifying what the case law already is. So we support that, and I'd be happy to take any questions.
Any questions of Mr. Lambert, members? Not hearing any, Mr. Lambert. Thank you for being here. The chair calls Cicilla Wood, testifying for House Bill 1899 on behalf of herself.
Good evening again. My name is Cicilla Wood. I'm a board-certified family law attorney, and I am here testifying in favor of House Bill 1899. And so many times we hear on a regular basis in conversations that nowhere in the family code does the code refer to a fit parent. Nevertheless, we know from the federal case law that the fit parent is the standard, and Troxell has defined what a fit parent is. So this bill would help, I think, move cases along much more quickly in that it lays out what a fit parent is for the court. It expressly says it codifies the presumption that a fit parent is working in the best interest of their child. It also has, of course, if you're not fit, or the significant impairment standard that we have in other statutes is included in this as a way to overcome the decision of the parent. And obviously it also provides for those situations where you're in a divorce or a SAPSR and you've got two fit parents, and then the court obviously is going to have to either choose one of them or do a compromise on both. So I feel this bill codifies the law and adequately anticipates the type of situations we see on a regular basis, and I am happy to answer any questions.
Any questions of Ms. Wood, members?
And I'd just like to say that is not the whole Troxell case. It's 25 pages long, but if someone would like the whole case, I'm happy to supply that.
All right. Thank you, Ms. Wood.
Thank you.
Chair calls Andrew Homer, Texas CASA, testifying
Good evening.
against.
My name is
House
Andy Homer. I'm the Director of Public Affairs for Texas CASA. We are here respectfully in opposition to House Bill 1899. Haven't had a chance to see the substitute. We sent out language on this to our network. A lot of you know we have 72 local CASA programs around the state, and really our primary goal in all of that is to make sure that we represent the best interests of children in the legal system. So trying to change that standard is very contrary to our core principle. And as we read the bill, it applies broadly, I think, to all cases that apply under the family code, is my reading of it. I'm not an attorney. And so we're particularly concerned about how this would apply in child protection cases. I think, you're talking about situations where parents have already shown they've demonstrated they're not able to be good protectors of their children. This would create a presumption that they are. It would create a high standard to overturn that. I'm not sure, and Representative Moody, maybe you could help with that, how we would determine whether they are unfit or not. Would there be a trial, an evidentiary hearing? This goes way beyond just codifying a ruling. So we are concerned about situations where you have adults who've already demonstrated their inability to be protective of children, and then all of a sudden they're given the rights to make these determinations for a child when they could, for instance, say we don't want a doctor to provide care under these circumstances. We don't think this is the best placement for a child, even though perhaps the Department of Family and Protective Services and everyone involved has concluded that a particular placement is in the best interest of the child, and the parent could override that, for instance. So really it just opens up a lot of things in this, and I don't think that this provision should apply to CPS cases. I mean, that's our bottom line on this. I think that you have substantially different legal circumstances there, and there's already grave doubt about the ability of parents or a parent in that situation, and they shouldn't be presumed that they're carrying out the best interests of the children. We should not presume that in these sorts of cases. So we feel very strongly about this. We let Representative Sanford's office know about our opposition, but we've just had this groundswell of concern from our network about this. And it's really trying to change the core principle of what the family protection, family practice is, and how we judge cases in our child protection system. So we think this has very grave concerns, and I'd be happy to answer any questions you may have.
Any questions of Mr. Homer, members? Mr. Homer, thank you.
I do.
Hold on. Representative Kane has a question.
Mr. Homer, you don't believe that there should always be a rebuttable presumption? That way, we kind of do that in all areas of our laws, even criminal, where we're innocent.
I think in this instance, if you've got a child who's already in the conservatorship of the state, there's already been a process that's determined that the parent didn't act in a protective fashion. And so I think they may have forfeited their right. That would be kind of my assumption as a non-attorney, and I know you're an attorney as well.
Yeah. Are you a father?
No.
Okay. All right. Thank you.
Any other questions, Mr. Homer, members? Thank you, Mr. Homer, for being here. Chair at this time calls Mr. Stuart McMullen. Okay. Mr. McMullen, before you testify, we have you down twice in our system.
Yes, sir.
Once on and one for. And we need to know, since you're testifying, I guess we need to eliminate the
confusion?
Yes.
I'm
Are you for the
testifying
bill or on the bill?
For the bill.
You're for the bill?
Yes, sir.
Okay. Do we have your permission to change it
Absolutely.
in the system? Okay. And we'll eliminate we'll just ignore the on.
Correct.
Okay. All right.
And I'm handing out a copy of my testimony.
All right. Okay. Thank you.
Thank you, Chairman Dutton, and the rest of the members of the committee, and special shout out to my representative, Tony Dale. My name is Stuart McMullen. I am with Americans for Parental Equality, and I'm testifying for House Bill 1899. As many people have noted, in 2000, Troxel versus Granville strengthened the following constitutional precedents. Number one, that parents are presumed to be fit. Number two, parents are presumed to act in the best interest of the child.
Number 3, parents can only be found unfit by clear and convincing evidence. And number 4, the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. In the decision, the Supreme Court supported these findings with several Supreme Court decisions, and I've listed them out in my testimony. For the sacrifice of time, I'm not going to go through all of them, but the 14th Amendment provides that no state shall deprive any person of life, liberty, or property without due process of law. And we have long recognized that the amendment's Due Process Clause, like its Fifth Amendment counterpart, guarantees more than fair process. And if we skip down to the bottom, in the Glucksberg case, in a long line of cases, we have held that in addition to the specific freedoms protected by the Bill of Rights, the liberty specially protected by the Due Process Clause includes the right to direct the education and upbringing of one's children. In light of this extensive precedent, it cannot now be doubted that the Due Process Clause of the 14th Amendment protects the fundamental right of parents to make decisions concerning the care, custody, and control of their children. Accordingly, so long as parents adequately care for his or her children, i.e. that they're fit, there will normally be no reason for the state of Texas, to inject itself into the private realm of the family to further question the ability of that parent to make the best decisions concerning the rearing of that parent's children. The Due Process Clause does not permit a state to infringe on the fundamental right of parents to make child-rearing decisions simply because a state judge believes that a better decision could be made. Due to the unconstitutionality of Clauses A1, 2, and 3, I'm testifying for this bill, but I would request that these two clauses be deleted because they don't protect the constitutional rights of parents. They should be replaced with, in number 2, in the temporary order section, that the court orders equal possession, equal access, and equal rights to both parents, or the court order is an agreement between two parents that are fit. And then in the second section of this bill, there should also be two changes. In B2, that should be stricken from the bill as well, and replaced with the court shall order equal possession, access, and rights to both parents. Or in B3, the order is an agreement between the parents who are both fit. And I've given you some written down those changes.
Can you go ahead and conclude
I'll
your
wrap it
testimony?
up.
Thank you.
Your duty is to make and pass laws that are constitutionally compliant. The current family code is unconstitutional, and HB 1899, with these suggested changes, will bring constitutional clarity to the family code and offer proper due process.
Thank you, Mr.
I'll
McMullen.
close with that.
Any questions of Mr. McMullen, members? Not hearing any. Thank you for your testimony, sir.
Yes, sir. Thank y'all.
Chair calls Will Francis, National Association of Social Workers, testifying against House Bill 1899.
Chairman Dutton, members of the committee, I appreciate the opportunity to testify. My name is Will Francis. I'm the Government Relations Director for the National Association of Social Workers Texas chapter, and I'm here testifying against HB 1899. I share CASA's concerns. It's really largely the impact upon DFPS and CPS issues that I'd like to raise. There is no one standard definition of best interest of a child, although there are excellent resources out there that cover the issue. A common definition reads, in the context of child custody cases, focusing on the child's best interests means that all custody and visitation discussions and decisions are made with the ultimate goal of fostering and encouraging the child's happiness, security, mental health, and emotional development into young adulthood. There are many others, and in fact, the Children's Bureau has an excellent booklet on the issue that covers definitions, research, best practices, and state examples of what each one looks like. I've provided you with a link, and I'm more than happy to provide you all with that documentation. As a former CPS caseworker, I saw the challenges faced by parents as they work services in an attempt to have their children returned to them. The balance between supporting the wishes of a parent and protecting children is the foundation of the work of the department. In my 2.5 years as a caseworker, I never went to a termination trial. I work diligently to apply social work principles and my professional skills to working with the families in order to achieve permanency outcomes that were always in the best interest of children. Sometimes these aligned with what the parents wanted and sometimes they did not, but paramount was the well-being of the child. In cases where there is suspected abuse and neglect, the court must consider the interests of the child first in order to facilitate the healing process and ensure that the child's safety is always the primary focus. HB 1899 can subvert that principle of child welfare and all of the work done by CPS by regulating the child to a secondary voice within the system. While I appreciate that the bill indicates that a parent deemed unfit does not maintain the best interests, the current statute, written over 20 years ago, is clear. In any issues of conservatorship, the focus is on the child and not the parent. At all times, the law defers to the best course towards healing a child, and while that often will involve parents, it is up to the court to determine the role that they will play. I had a piece on how unfit parent is not in Texas statute, but apparently the committee sub, which I have not seen, may cover that. I appreciate that that definition is there, but I still have concerns about how it impacts DFPS. And I do understand the intent of the bill, but I take issue with the fundamental principle behind it, that a child in an abuse and neglect case must have their voice delegated to anything less than the most important consideration. Thank you for the opportunity to testify, and I'm happy to take any questions. Thank you.
Mr. Francis, you mentioned you take issue with the fundamental principle behind it. Could you please elaborate?
The fundamental principle that in any instance where we have abuse and neglect, the child's best interest is going to involve anything other than what is ultimately there for the child. If that could be defaulted upon, deferred upon, or otherwise ignored by a parent who's involved in one of those cases, I think that that's contrary to the whole mission of child welfare and everything that the state does to protect kids.
If there was a hierarchy of persons who determine best interests of children, how would you rank that?
Are you talking, I mean, specifically, I'm speaking for abuse and neglect cases. Mm-hmm. So in those cases, it would be the court.
Respectfully, sir, you're mentioning an exception, so I'm trying to lay out a definitive rule, and maybe there's exceptions. So would you say parents or the government or society is the kind of maybe the first tier of determining the most important thing for children?
I would say if we're talking about the definition of a fit parent, which I assume is what you're referring to, then I would say it was parents.
Okay. Thank you, sir.
Fair enough.
Members, any other questions? Mr. Francis, thank you for your testimony.
Thank you.
The chair calls Judy Powell. Ms. Powell, if you would please state your name, who you represent, and if you're on for or against the bill.
Hello, my name is Judy Powell, and I am for the bill. I am with Parent Guidance Center. I'm Communications Director and co-founder of Parent Guidance Center, and we help parents involved with CPS. And wow, I didn't really think this was a CPS bill, but as I listened to it, I was struggling to get a client angle on this because we have some clients, we help clients involved with CPS, but we also have had some other mixing in of custody cases and stuff. So I really saw this as more of a child custody case because when CPS is called and they actually remove a child, they should have evidence to remove that child, and so I think you would have plenty of evidence that you're on the track of unfit parent here. What we don't have is evidence, for instance, in a case that we had with a mother with a disability that I want to kind of bring the case to, face to a case here. Her ex-husband had constantly been using CPS against her and making calls, so we got involved, but there was no evidence she was not abusing her kid. She was surrounded by attendants. You know, she had the use of a wheelchair. The kids were in school. They went to church every Sunday. So her ex-husband, since CPS wasn't working out for him, because she was not actually abusing her children, he filed some temporary orders on her that ended up lasting about 1.5 years. And so when I got involved in the case through some other advocates, she could not afford an attorney, and so this is the kind of case that I'm thinking of with the temporary orders, not CPS cases. So eventually, through the POL line, parenting order, legal line, we were able, pro se, to help her with some documents because the husband, he had access to an attorney and she did not. And so through that hotline, they helped her, and I helped her, you know, kind of formulate these documents, and we got visitation back for her, but it was an uphill battle. And so I really was thinking that this bill would be more about divorces, maybe a little bit of grandparent access where they're trying to take, you know, children and place them with grandparents rather than the children being with the parents when there's no unfitness proven. But I really think in a CPS case, I really hope that you have proven your case of unfitness at that point. But in this case, with this woman, there was no unfitness proven. She went to court She was unrepresented. She had no idea what was happening that day. And the judge actually gave temporary orders to the husband on hearsay. Her ex-mother-in-law saying, I think she's a drug addict. And, her ex-husband saying, she's abusing the kids. But nothing had to be presented. Had she had a lawyer and access to that legal representation, they could have easily shown that the child was doing well as a 9-year-old boy in school. They were attending church, all these kind of things. So the temporary orders would have never happened because she would have actually been proven fit that day in court. And it was really just a squabble about child support in the end when we, looked at all the factors. So anyway, that's the kind of case that I'm thinking of, not CPS cases here.
All right,
And
Ms. Powell, thank you for your testimony.
Could I answer your question about the
Hold
alcohol?
on, Ms. Powell. Hold on,
I did
hold on.
actually.
No, thank you.
No?
Hold on,
Okay.
Hold on. Are there any questions for Ms. Powell, members? Ms. Powell, thank you for your testimony. Okay. Chair at this time calls William Morris, Texas Family Law Foundation, testifying on behalf of the foundation and himself against House Bill 1899.
Good evening. Thank you, Mr. Chairman and members of the committee. My name is William W. Morris. I am representing the Texas Family Law Foundation and myself as a former associate judge and a family law practitioner for 44 years. Let's start with what Troxel isn't. Troxel is not a suit between parents, and Troxel specifically says there is no issue here of fit parent. Neither party raised the issue of fit parent. So Troxel was not about fit parents. Troxel was about a very broad statute from the state of Washington that said basically the court up there could order visitation with any person if it was in the best interest of the child. And the court specifically said, we are only ruling that this statute is overbroad. We are not saying what a parental statute should be. That's specific to Troxel. Having said that, let me address the bill. The bill first talks about, the substitute first talks about temporary orders and says except to set out in A1, temporary orders shall be made for the safety and welfare of the child. If you go down and you look at A1, safety and welfare of the child could not be addressed under the scenarios set out there. This bill says that somebody is a fit parent if they can adequately provide for the child. That's a pretty low standard, but if you have two fit parents, that can be a very wide gap between who's fit. If the parents can agree what's in the best interest of the child, they would not need the court to assist them in that. So basically, what this bill is doing is overturning years of case law and statutory law that says the courts are to do what's in the best interest of the child. In the part that deals with final orders, unless you have two unfit parents, the best interest is out. It's gone. There is no use for the best interest of the child. This bill takes away from the courts of the state of Texas the right to resolve differences between parents, because if one parent can't adequately provide for the child, the other parent's wishes prevail, period. End of story. No judicial input. If the parents could agree, they wouldn't be in court. If the parents could agree that what was best for the child, they wouldn't need the court to help them reach those conclusions. Often the cases are very disparate in what the facts are or what the thoughts about the facts are. And to have to require one parent to call the other unfit in order to get custody of a child, I don't think is in the best interest of a child. Thank you.
Any questions for Mr. Morris, members? Mr. Morris not hearing any. Thank you for your
Thank you, Mr.
testimony.
Chairman.
Thank you for being here.
members of the committee.
Chair calls Kelly Osley Flores, representing the Texas Family Law Foundation and herself, testifying against House Bill 1899.
Chairman, members, my name is Kelly Osley Flores, and I'm here representing Texas Family Law Foundation and myself. I am a family lawyer in this area and have been doing it for 22 years. My fundamental problem with this bill, I'm not going to repeat some of the things that have been said, but I am against it. And the reason I am against it is I believe it puts parents above children. I got into this business because I care deeply about children. And in my opinion, this bill will make two fit parents attempt to find animosity between each other and try to say you're unfit, so I'm the fit parent and I rule. Current law, over 20 years, says that judges look at the best interest of the children. You don't put parents above the children. What this does is it puts parents above what is best for their children. And I believe it's going to create more expense and it's going to create more work for me because there'll be animosity between the two parents and they'll be more adversarial because they're going to want to prove the other parent unfit. The majority of the cases I deal with on a regular basis, I'd say over 90% of my cases, you have two fit parents. And a court has to decide what's best for them. And I believe this raises it to the parents and doesn't allow the court to decide what's in a child's best interest. Thank you.
All right. Thank you, Ms. Osley Flores. Any questions, members? Thank you for your. I think Representative Schofield has a question.
It seems like the overarching theme of the folks who are against this bill is that it should be in the first instance the judge who decides what's in the best interest of the child and not the parents. And it seems like it is the overarching theme of the author that it ought to be the parents who decide what's in the best interest of the child unless they've been proven not to be fit. Why is it that the first person we turn to, the first person presumed to speak for the best interest of the child is a judge who doesn't know them, compared to their parents if the parent hasn't found not to be fit?
If you have two fit parents, first of all, many fit parents are never in a court of law, okay? And then what you are doing is by adding that if someone can show someone unfit, that other parent, the parent that wins, the fit parent, they get to decide it completely. So there are times when you will have an unfit parent and a fit parent, but let's say the fit parents, what they want to do, the court doesn't see that in the child's best interest.
So why would we put a judge who isn't related and doesn't know the child above a fit parent who has given birth to the child or is the father and has raised them their whole life? If a parent who is fit disagrees with some stranger with a law degree about what's best for the child, why would we decide that it's the guy with the law degree who doesn't know the kid who gets to be the paramount decider and not the fit parent?
Well, let me give you a specific example.
Well, please answer my question first and then give me all the examples you want.
Well, it's going to answer your question. Your question is, and here's an example. I was involved in a case where there was a mother that was unfit. There was a father who was fit that had not seen the child in 10 years.
Well, then he wouldn't be fit under this statute because
Who
the definition
determines what fit is?
The definition of this statute is a parent who does not adequately care for the parent's child. If he hasn't seen him in 10 years, there's nobody who could determine that he has been adequately caring for the child. He hasn't even seen the child.
You don't have evidence that he wouldn't. You don't have evidence that he couldn't adequately care for that child.
No, it doesn't say wouldn't. It says does. That the parent does not adequately care for the child. Under the definition of this statute, the example you gave me, the person could not be found to be a fit parent.
I don't necessarily agree.
You're going to tell me that in your opinion, someone who has not seen a child in 10 years can be found to have been adequately caring for the child during that time?
No, I'm not saying that.
Well, you just did. But let me also ask you about the case that I believe Mr. Lambert raised when he came up, which wasn't one parent versus another. It was grandparents who didn't like the fact that the parents, both of whom were fit, chose to homeschool their child and sued to try to get conservatorship away from the two fit parents who wanted to homeschool their child. Again, why would a judge's opinion of whether the child should be homeschooled be paramount over the two parents, both of whom are adequately caring for their child?
The current law does not let a grandparent insert over two fit parents. I don't know his specific case and what he's talking about.
What you do is you allege the parents aren't fit because they're homeschooling.
He's talking about Troxel.
I don't think a court would find two parents unfit because they homeschool their children. I don't agree with that.
I certainly don't agree with it either. That's part of why we're here. But thank you. I appreciate you answering my questions.
Any other questions, members?
Yes.
Oh, Mr. Kane.
Ma'am, are you familiar with the origins of the best interest of the child doctrine?
Yes.
What are they?
Well, the Hawley factors, case law
No,
is
ma'am.
trying to determine.
In what century did the best interest of the child factors, kind of the concept, begin in family law?
My understanding is in this century.
That's correct. So there's kind of a lot of problems in this century as well. Do you believe maybe in an expanded view of the in parens patriae doctrine? In parens patriae, should the government control children's lives?
No.
Well, that's what the best interest standard is.
Not if you're in a court of law, you're asking the court to make a decision about your own children.
Do you believe that parents should be able to decide how they raise their children as they see fit?
Yes.
So you're okay then with parents being above their children?
Yes.
Correct me if I'm wrong, I thought in the beginning you said what was wrong with this bill is it's putting parents above children.
The problem is not all parents see what's in the best interest of their own children.
You know, that contradicts the concept that they get to raise them as they see fit.
Yes, but when you're in a court of law, you're asking a judge to make that decision for you.
I think the members are tired. I'll stop. Thank you, ma'am.
All right, any other questions, Ms. Flores, members? Ms. Flores, thank you for your testimony. Chair at this time calls Scott Momper, testifying on behalf of himself, testifying for House Bill 1899.
Yes, sir. Thank you for your time. My name is Sergeant Scott Momper, United States Marine Corps. I'm here to testify on behalf of Hill Bill 1899. As a United States Marine, I took an oath of enlistment to support and defend the Constitution of the United States against all enemies, foreign and domestic, and to bear true faith and allegiance to the same. I never took that oath for granted. And as a Marine who lost blood on foreign soil, that oath means everything to me. I can tell you that the rights that we talk about here of fit parents are near and dear to me as a parent. And I think that we can, as has been brought up several times here, that we say if two fit parents should know what is in the best for their children before a judge should, as they've raised them from time of birth. I struggle with the concept of how we stray from two fit parents just because there's a dissolution or whatever, not being able to make that decision, even if they can't agree, putting that in the hands of a judge to automatically determine what is best when they don't necessarily understand the entire situation of that child or those parents. And I think this bill clearly establishes that two fit parents should be able to make that decision. And as a point was raised that it would raise contention between two parents where one would say another parent is unfit. It's not as easy as saying a parent is unfit. There has to be clear and convincing evidence to prove that a parent is unfit, whether it be CPS through an investigation, and at that point, that would be proven. It wouldn't just be a basic allegation that one parent can raise against another. I think to go down that path leads us in a dangerous direction, to be able to say that that is a byproduct of what would happen because of this bill. You as our representatives have also taken an oath very similar to the one that I took. And that I ask that today on this bill you do just that. That y'all protect the Constitution as I did. And that at some point you do adopt Mr. McMullen's suggested changes and that this bill does get approved. I appreciate your time today and consideration on this matter.
Mr. Momper, thank you for being here. Any questions of Mr. Momper, members? Not hearing any. Thank you for your testimony. Thank you for being here. Chair calls Chris Merritt, testifying against House Bill 1899.
Good evening. My name is Chris Merritt. Again, I am with the Texas Family Law Foundation. I'm a board-certified family lawyer. Been practicing for about 20 years. The foundation is in opposition to this bill. You've already heard several of the reasons, and I know we're late, so I'm going to kind of try and deal with two quick ones that I want to address. One of them is the lack of ability for a judge to look at a situation and deal with it maybe in a proper way for the children. It takes all the discretion away from our judges as we're sitting on the bench in certain situations. One of those situations is you have a husband and a wife, let's say. Let's say dad unfortunately succumbs to an opioid situation where, at least for the moment, he's an unfit parent. But he's trying to get therapy. He's trying to do the right thing. In that situation, under this bill, since we have an unfit parent, the court is required to do everything that the other parent says with no discretion. So if the other parent says, no visitation for dad, not even supervised, the child can't talk to dad any longer, can't see dad, dad has no rights and duties with regards to this child anymore. Under this statute, while the court may want to say, look, we need to have an ability for this father to work his way through a plan to get in a better situation and to be able to see this child that has been living with him and that he has raised, that he has coached the soccer team, all these things that have been involvement in this child's life, and now is entirely cut out because that's what the fit parent wants. All discretion is gone. The other point that I want to visit about is, and it was brought up kind of in the questioning, so I do want to address it. One of the things that we have to understand is if two fit parents come to an agreement, they can decide what's in the best interest of their child, or they decide what they want to happen to their child. The court will adopt that situation. What we are primarily dealing with are two parents who are going to court who have different views of what should happen with their child. So they're saying, Judge, I want you to do A, I want you to do B. Now, the judge has to have some foundation when the judge is sitting there trying to figure out what the judge is going to do. If they're both fit, what is the standard? What's he supposed to look at? Is he supposed to look at, well, I like what dad wore, I like his suit better? No, he should be looking at what's in the best interest of the children. That should be a standard to make a decision when these two parents can't come to an agreement. And that's really what we're trying to deal with. And that's why we don't believe that this bill, or that we oppose this bill. And I'll open myself up to questions.
Any questions of Mr. Merritt, members? Yeah. Ms. Theory has a question.
Yes.
Thank you. I wanted to just clarify something to your point. I'm trying to just, and this is just to clearly understand a practical outcome. So starting on page 1, down at line 21, well, actually I'll start about that. On line 9, it basically is saying the court, as the law reads now, may make a temporary order for modification, safety, welfare, for conservatorship, temporary support. So that would be like a temporary order for child support, preventing a party from disturbing the peace, and preventing a parent from removing the child from the area. So that's as it is now. The court can do that, correct?
Yes, ma'am.
Now, this language would say the court may not do that. For example, couldn't issue an order on temporary, I'll just give the example, temporary child support, contrary to the wishes of the child's parent, unless, number one, that parent is deemed not fit. So in this instance, how would the court issue any kind of temporary support if one parent said, if the court said, well, you're going to pay $100 a month, and one parent said, no, I don't agree. That's against my wishes.
Yes, ma'am.
But that's a still fit parent.
Yes, ma'am.
So stopping there, would that prohibit the court from doing anything? I mean, they couldn't do it at that, and I'll go on to number 2 afterwards.
Well, and honestly, that was a discussion that we had as we were going through this, where I honestly couldn't tell you, and it looks like absolutely the argument could be made that under this part, since there is no agreement, you couldn't do it as the court.
Okay, so I'll go there. So in that instance, and I'm going to follow the exception, if you'll just bear with me quickly. So in that instance, the court couldn't even issue any kind of support unless the exception, or we'll even go back to saying, well, I can't stop this parent from taking the child to Florida. And then the other person says, well, I don't agree, so the court couldn't do that because the parent would be fit. Unless the exception says the court determines that failing to render it would cause significant impairment to their physical health or emotional well-being. So there's that catch-all. But then on number 3, I wanted to ask you to explain that. Or if the court is rendering the temporary order contrary to the express wishes of a fit parent. So that would mean if they're doing it against what this fit parent doesn't want, at the request of the child's other parent who is a fit parent. So I'm reading that to be that there would be a quagmire. It would never resolve itself because you've just told the court you can't do it contrary to the wishes of the fit parent because they don't like it. But you can if it's at the request of the child's other parent who is a fit parent. So how does it ever solve itself?
And that's our opposition.
If they're
to
both
this
fit
is
parents.
They're both fit parents. There is no answer to that question. I apologize.
Okay, so in this instance, the court, there was just nothing would happen?
I'm not sure under the bill. I mean, that would absolutely be, or could be my argument if I'm in court and this were to be the law that, hey, you can't do it because I have a fit parent. You can't go against the wishes of my fit parent, who is my client.
But you can go against the wishes of that fit parent at the request of the other child's parent who is a fit parent, but they might not be agreeing with that fit parent. So
Correct.
That's what I'm trying to. So
right.
Is
and so
it
the
that
judge
it would
has
only
no
work
guidance.
if there's an agreement?
Well, and assume that they would have an agreement, then that would be fine.
Need it.
Then they wouldn't need this.
Okay, so
Right.
I'm just trying to get the real life impact. Okay.
I understand, Representative Terry, and that's part of the problem is that this bill deals with a situation where you have two parents who can't agree because they're going to a judge. They're asking this third party to make a decision. Well, we have always said when that third party decides between option A or option B, they should put the kid's interest first to make that decision instead of mom's interest or dad's interest. This bill takes away that. So there is no guidance for the judge or for anybody to decide how to make a decision.
If they're both fit parents.
If they're both fit parents, which in my practice is 95, 98% of the cases. That is such the exception that there is an actual unfit parent in my practice. In the 20 years plus that I've been practicing, that is such an exception.
Okay, thank you.
All right, thank you, Mr. Merritt.
Thank you for your time. I know I went
Thank
over.
you, Mr. Merritt.
Appreciate
That's okay. Chair at this time calls Rhonda Finney. Ms. Finney is testifying for House Bill 1899 on behalf of the Americans for Parental Equality, Speak Love, Texans for Parental Equality, and herself.
Hello. Thank you, Mr. Chairman and committee members. My name is Rhonda Finney, and yes, I have a group called Speak Love. SPEAK stands for Shared Parenting, Encouraging Advocacy for Kids. I'm also an advocate for Americans for Parental Equality and Texans for Parental Equality. I am very much for this bill. I do implore that you please consider the changes that Stuart McMullen recommended. Those changes are absolutely necessary for this bill to be truly effective and adequately protect parents and children. I very much like the language used in this bill. However, I find it very interesting, and I want to make note to the opposition to this bill by the individuals who have spoken. For example, Mr. Homer stated, or maybe it was Mr. Francis stated, that the court has done an adequate job determining a parent is unfit. That is not always the case. I am an alienated parent, and I have been severely weeded out of my son's life. I am a fit parent. The problem is that there's an assumption being made There's an assumption that both parents have equal access to sufficient and adequate legal representation. There's also an assumption that the attorneys will do a very good job representing their client. I have had 4 attorneys, and I can tell you that unfortunately I learned all too late a lot of the processes that need to be done in the courtroom, such as objections. It is the job and duty of an attorney to represent their client. However, often one attorney will denigrate the other, will denigrate one of the parents. Mr. Morris had stated that this bill takes away the power of the courts of Texas to determine what's in the best interest of the child. That's needed, because when you have an attorney who is denigrating a parent to deem that parent as unfit, that they're willing to say whatever and manipulate evidence, and then that judge is ruling by that skewed evidence, then there's fundamental problems. It is necessary to have this language passed from this bill to give adequate protection to those parents, so that if a parent is deemed as an unfit parent, that there is absolutely clear and convincing evidence, and that also on record then that judge has to state exactly the basis for that determination. I also want to point out some things that we're looking beyond, such as biases. As you know, everyone
Ms. Finney, can you wrap up your testimony,
Okay,
please?
I'm sorry.
Thank you.
Please keep in mind that everyone is biased to a certain degree. And as we've heard, and there have been questions done that have been very, very thorough, asking, how do you think that a judge would know, who has very limited information about that parent, that judge would know what's in the best interest of that child? Another thing that I want to point out is so often CPS is able to identify physical abuse and neglect, sexual abuse, but when it comes to psychological abuse, it's very hard for them to be able to find clear evidence and support that in a court. This
All right, Ms.
bill
Finney.
will help protect those parents and children that are experiencing psychological abuse.
Thank you for your
Thank
testimony. Any questions of Ms. Finney, members? Ms. Finney, thank you. That's okay. There are no questions. Thank you very much for being
Thank you.
here. Chair calls Brady Howel, testifying for House Bill 1899 on behalf of himself.
Chair Dutton, members of the committee, I won't waste too much of your time. I believe you probably elucidated most of what you need to hear, but I'd like to say that I believe I'm in support of this bill because it is codifying law, which is common sense, that the state shouldn't act until it's made a determination that it has the authority under the parent's patria. It is that simple. The parent acts in the best interest of the child until it is determined that he's an unfit parent. It's strong protection provided by the 14th Amendment. That's not just Texas law, it's not just federal law, it's deeply embedded in both. And that's all I have.
All right. Any questions, Mr. Howell, members? Mr. Howell? No, I don't think there are any. Thank you very much. Thank you for being here. I don't have any other people wanting to testify. Is anyone else here who wants to testify on, for, against House Bill 1899? There are a number of people registered not wishing to testify on House Bill 1899, and the record will reflect those witnesses. If there are no other witnesses, the chair recognizes Representative Sanford to close.
Thank you, Mr. Chairman, committee members, for your patience and on this late evening. We received an email from Legislative Advocacy Team co-chair from one of the groups that testified against the bill this evening. The correspondence was shocking, to say the least, and I want to share with you some of the excerpts because I believe it gives us an insight into the mindset that this bill hopes to address. He says, my history tells me this bill treats parents as good, responsible actors. This is simply not the case. In fact, rarely the case. Unfortunately, this bill puts the parents in the forefront where they have shown time and time again they have no right to be. This is not a question of putting, these are my words now, this bill is not a question of putting parents above children, as someone previously testified. It's about putting parents above the government as it relates to their own children. With that, Mr. Chairman, I'll close.
Any questions for Representative Sanford, members? Thank you,
Thank
Mr.
you, Mr.
Sanford.
Chairman.
The chair withdraws the committee substitute for House Bill 1899, and it's the chair's intent to leave House Bill 1899 pending without objection. Chair at this time calls Representative Stuart.
Thank you, Mr. Chairman and members.
And the chair at this time lays out House Bill 4198 and recognizes Representative Stuart. And I understand you have a committee substitute.
There is,
as well.
sir. Yes, sir. And that committee substitute is just the Ledge Council draft of our original bill.
All right. The chair at this time lays out the committee substitute, offers up the committee substitute for House Bill 4198 without objection, and asks Representative Stuart to explain it.
Thank you, Mr. Chairman and members. Appreciate you all giving me time this evening. This idea, actually, of this legislation was brought to me by an adoptive parent that has been crafted with the Assistant Attorney Jim Handy, who I believe will be speaking a little bit later, who has nearly 20 years of experience assisting birth mother and adoptive parents in many different states. I'm here to lay out 4198, and as we discussed, it's got the committee substitute here. There are two legal processes for private adoption in the state of Texas. Adoptions facilitated by agencies and independent adoption facilitated by attorneys. Both agency and independent adoptions seek the same outcome: to provide expectant mothers who choose not to parent or feel unable to parent with the option to place their child in the care of a parent or parents who desire to parent the child, and to provide those children with the best opportunity for a wonderful life in the care of a strong, nurturing family situation. This is noble legislation purpose, and one that I believe we will all want to support. HB 4198 seeks to assist birth mothers who choose to place their child for adoption through an independent adoption with an opportunity to receive financial assistance from necessary pregnancy-related expenses if and when they are unable to provide for them on their own. This opportunity currently exists with agency adoption in Texas. It also exists for independent adoptions in many other states, but not here in Texas.